The National Prosecuting Authority says collaborating with the State Capture Commission will be key in ensuring that effective follow-through on the recommendations is actually seen through. As a process, the NPA and the Commission's leadership met last week and agreed that there is a need to end impunity and corruption in the country. Let's get an update on this then. Bring in the independent Directorate spokesperson, Sindisiwe Seboka. Sindisiwe, good to have you on the program this afternoon. Good afternoon. What is the extent of your involvement, your collaboration, as things stand at the moment?
So you would know that the amendment of the State Capture Commission Regulation 11 took place in 2020 in June. That basically allowed for the Commission to be able to share information with law enforcement, and it also allowed the Commission staff, once the Commission wraps up its work, to then be employed within law enforcement, or basically to be able to share information that they thus acquired while being in the employ of the Commission. So from that point, there were initial talks when the investigating directorate was established in 2019. The NPA in its broad totality had sent a couple of requests to the Commission, but prior to the amendment of that regulation, there was a bit of a challenge. However, currently there has been a better sharing of information between the two establishments. However, after having met last week, we are anticipating that the pace in which the information is shared will be quickened.
Let's talk then about the sort of investigations, because the caseload from the State Capture Inquiry, as far as the findings and recommendations, is expected to be quite massive. What will you be able to take on, and what would be left to other law enforcement agencies?
You would know that the NPA in its totality does not necessarily enroll matters on its own. It's for law enforcement, being the investigative arms. This is SAPS, this is the Hawks, IPID at times, to open dockets and then take it to the NPA for prosecution decisions. However, there is a unit, you would know, the ID Investigating Directorate within the NPA, which, working with law enforcement, is able to basically enroll matters through authorization by the director. What we can do, and what we've stated publicly, is that we've already declared 82 investigations. Of those 82, about 20 cases have already been put on the roll. Of those, a significant amount, about 15 odd, emanate from the work of the Commission that are currently before court, enrolled as early as 2019. So what we're going to be doing is enrolling further matters within the next 6 months.
And let's talk about the speed at which you hope to do that work, because once more, there could be hundreds, if not thousands, of cases coming from this process. How are you staffed to make sure that you're able to do all of that? Because that is one of the concerns, isn't it, at the moment among South Africans, the pace at which the prosecutions will happen.
What I must clarify off the bat is that the complex corruption matters that we're looking at are quite complex, quite technical. However, we're employing a variety of means. First and foremost, there has been an NPA task force that has been put in place in order to look into how exactly the enrollment of these matters will be. Additionally, there has been a dissemination from the various NPA regions as to how many cases will you be contributing to the state capture matter, or matters arising from the State Capture Commission. The task force then coordinates so that there isn't a duplication, that while the ID is working on something, not a similar matter is being done in the region. So what we're going to be doing, the task force has already been put in place. Various regions have been asked about various matters that they're going to be contributing to this 6 months priority. The ID currently has already committed about 3 matters to be enrolled. But what we will be doing is that we will be following the evidence. We will not be looking or hunting down for particular persons, but following the evidence after having read through the recommendations. Currently, we must also state the report 3 that came out that spoke about the SASA, 3 matters from those recommendations, the recommendations that only came out now. 3 matters already been put on the roll. This is the Vincent Smith matter. This is the 1.8 billion Busasa main matter, which involves Lindamzi, former correctional boss. And there's another one which includes Mr. Bonifacio. So what we're essentially saying is that some of the matters already on the roll, of the over 15 that I've mentioned, some of them emanate from recommendations. So we preempted the recommendations because we're following the evidence. But more can be expected, more matters will be enrolled.
There will also be several people, or a dozen people, who wish to take the findings against them on review. Do you expect that to pose somewhat of a complication for you in proceeding in some of the matters?
We must also clarify that the mandate of the Commission is on a civil basis. So if a person would like to take the recommendations under review, looking at the Commission's recommendations made, it does not bar us from continuing with our criminal matter, because we would have followed a case docket that was opened and then we authorized, which is a different route. What we're going to be doing with the recommendations found is to compare notes, because some of the stuff had already been investigated. So compare notes, what have we missed in our investigation that is crucial that the Commission might have found. But what we must also caution against is that the Commission is looking at these and making these recommendations based on a civil route. While we are making these court cases or asset forfeiture dealings that we take to court based on a case that is beyond reasonable doubt, which is a heavier burden. So we will not just take recommendations and just take them to court. There needs to be thorough investigation and evidence in support of these matters.
And I'm glad you mentioned that, because there may be somewhat of an expectation that once one is implicated and recommendations are made against the person or the entity by the Commission, there'd be an expectation on the part of some people that would automatically mean that this is a matter that's going to court. And as you say, that's not exactly how it's going to go. So how much of the findings do you think will be an aid to your work? I know you said you're going to compare notes, but what are the parameters of that sort of note sharing?
So we cannot disregard the magnificent work that the Commission has done. However, what will then take place is on a case-by-case situation. Like I mentioned, with the third report that came out, they recommended prosecutions on a variety of matters pertaining to Busasa. The recommendations that the Commission found are almost identical to what the state had also presumed and taken the matter to court on. So there are instances where the evidence thus provided, or the recommendations thus are provided, there is evidence to book that we can get on our own using our investigative powers, using the Hawk, SAFs, and IPID. But what we must caution on, that it's on a case-by-case basis. If there are situations where we find that there isn't enough information or evidence for us to be able to enroll a matter, then we won't enroll a matter, because at the end of the day, the balance is not the same. The Commission's balance is on probability, while our matter we need to do beyond reasonable doubt. So it's quite a heavier burden. So it's on a case by case. We cannot use one brush for all the cases or all the recommendations that will be brought.
Sindisiwe Seboka, good to speak to you. Thank you very much for your time today.